With exams coming up, some of you might be wondering, how do I ace my exams? Well, I'm going to offer you a technique which can instantly improve your score on all your essay exams, no matter the subject, by following one simple piece of advice. Now, before you start watching this, I'm going to invite those of you who are taking a course in law, especially contract law, to pause here. I have a mock essay, a sample essay, that I'll invite you to take by following the link in the description below. Take that essay, give yourself 1 hour to take that test, and then tune back in to see how I would approach it. I think this will be the most illustrative way for you to learn how to approach exams differently. I've also included a cheat sheet or a tick list of issues that come up in contracts, essays generally, that you can use to help you take the assessment. If you're not in a contracts course, don't worry. The first part of this video will still be useful to you because I'll still share a technique that you can use in any course where you are assessed or tested with an essay. So pause here, take a minute or 60 to attempt that contracts exam, and tune back in for my approach to how to solve the problem with a strategy that can help you with all of your exams in all of your courses. Welcome to the exam review. This is really about how to write an essay answer, and specifically how to write an essay answer for law school, and more specifically how to write this essay answer for contract law. But I think what we'll cover in the next 45 minutes or so will help you with any essay that you're writing, because the first and foremost part of answering an essay question is answering the question. Answering the correct question, the question that is asked by the test. Many tests include what are called red herrings or misleading facts, and the way to approach an essay question like this one or like any essay question, in my opinion, is to begin with the question itself. So that will give you some guidance as to what are the issues that are being brought up, what are the topics that you need to discuss. Given that this is a contract law course and a contract law final exam, you may, it's an open book exam, you may have a checklist of what those issues are. And I've summarized basically the chapters in the book to remind myself what are the issues that come up in questions like this, so I am ready to spot them. But again, first and foremost is you need to answer the question, and so I would begin by reading the question itself, because that will help you understand how to even read the facts that precede it. Some of those facts may be irrelevant, some of them may be background, some more important than others. So question number 1, discuss the best legal claim Malhorta can make in order to prove the contract to sell site number 197703001 is invalid or unenforceable. That's the question. Legal issues regarding invalidity or unenforceability. And within 5 or 10 seconds of reading, I hope that you would have spotted that this is what we call a defense. These are defenses to contract formation, right? These are topics that make contracts unenforceable. And there are a limited number of what those are. We know that there is the statute of frauds, mistake, misrepresentation, undue influence, duress, and unconscionability. Those are the set of things we generally call defenses. We also learned about an incapacity defense. So already, within a few seconds of reading your essay question, you should have some idea what you're being asked to answer. And in this case, this was about contract defenses, things that render contracts invalid or unenforceable. And moreover, legal claims, as in not equitable reasons. We also learned the law and equity distinction throughout this course. And so hopefully, again, without having read any of the facts, but only the prompt, we have in mind what are the defenses to contract formation. And again, they are statute of frauds, mistake, misrepresentation, undue influence, duress, unconscionability. Provide Malhorta's best arguments in favor of this claim and provide Gundy's best arguments in defense against this claim before concluding who should prevail in this claim. The rest of the prompt is just telling you to use our standard plaintiff-defendant argument on both sides model, and that's reinforced by the italics at the bottom. Respondents earn credit for discussing relevant issues using IRAC. And so all of this should be familiar, all of that second sentence. This is just the way we've been trained to perform all throughout the semester. We're doing it once again on the final exam by spotting the issue, and we know already the issue involves some type of defense, stating the rules related to that issue, which will of course depend on what issue we determine, articulating arguments on both sides, which will depend on the rule and the facts, and then concluding. We also have a second essay question. So let's go ahead and take a look at that, because we might as well read the fact pattern just once and, or at least during our first pass, gain some knowledge about what's being asked. Assuming arguendo that Malhorta can convince the court as a matter of law that Gundy is not entitled to the site. In other words, assuming Malhorta wins the debate posed by essay number 1. We don't know that she does, but we're going to assume that. Provide the best argument or arguments Gundy will make as a matter of equity. So you're being directed to resolve as a matter of law and equity whether a contract can be enforced. So we already know only by reading the question and not any of the facts that we are dealing with defenses and equitable counter defenses. Also provide Malhorta's defense to Gundy's argument before concluding. Once again, the prompt is inviting you or reminding you to use the IRAC paradigm to make arguments on both sides. So now let's turn to the fact pattern for the first time with our eyes looking towards what are the defenses and counter defenses that are raised by this fact pattern, and how does the fact pattern raise them. And once again, we have our maybe cheat sheets handy here where we know that our defenses involve, well, the general incapacity defense, the statute of frauds, mistake, misrepresentation, duress, undue influence, and unconscionability. So we have a limited scope of things that we are looking for. Karen Gundy, a world-famous professor, I'm reading the fact pattern now, specializes in the science of cultivating marijuana for medical products. Okay, nothing necessarily there yet. To test her radical theories about growing cannabis, Gundy sought to purchase a parcel of land. Okay, we already have a clue, right? Land is one of the categories of contracts subject to the statute of frauds. Now, this is too early to conclude that this is a statute of frauds question, but we have a hint in that direction. And again, we know that statute of frauds is one of the defenses, and we know we're being asked to find a defense and a counter defense. She places an advertisement. All right, this could be a red herring. Why? Advertisements are an issue in contract law as well. We have a question of whether advertisements are offers. But is that a defense, or is that a legal basis for a contract claim? So I remarked on here advertisement and sort of set it aside for a minute, because it doesn't, I don't want to ignore this fact, but I am setting aside things that do not immediately fall within my zone that I've identified as the likely issues that I'm being asked to answer. Anil Kumari Malhorta, MD, saw one of Gundy's signs or advertisements and called the number. They spoke for an hour, during which Malhorta explained that she owned site 197703001. We'll call it the site, located at address, that was contaminated by leaking underground petroleum tanks. All right, I noticed this fact as well. Like, this contamination seems like some kind of material fact. And we have rules regarding mistake and misrepresentation. When a person either has a belief that's not in accord with the facts, or makes a statement, an assertion that's not in accord with the facts. Now, those are also defenses. So as I'm reading this, I wrote down the word assertion, and then underneath that I wrote mistake, misrepresentation, defense. I'm just thinking, what are the potential defenses raised in this question? What is this really asking? Gundy said she would purchase the land anyway if it were cheap enough. Okay, so this was a disclosed fact. They both are aware that there's leaking petroleum. That's not likely to be the defense. Malhorta offered to sell the half-acre parcel for $10,000, provided that Gundy would pay her that week. All right, I wrote down on the side here, condition. because we may have a question, and for that matter, this fact pattern on an exam could have more questions than were presented here, but I will do X if you do Y is the form of a conditional statement. And so we have a fact here which implies conditions. Conditions are not defenses to contract formation per se, so they seem to be outside of the scope of what the prompt has asked, but I noted it anyway because I want to make sure I understood the prompt correctly. Because Malhotra plans to leave for a 2-week mission to India with Doctors Without Borders. Gundy agreed. So we seem to have offer and acceptance, once again confirming that offer and acceptance, also known as mutual assent, is not the issue being tested on here, right? There are a requirement of offer, acceptance, and consideration in a contract, and that acceptance has to be made while the power of acceptance is alive and well. And we have a conversation where the offer and acceptance seem to appear during the conversation. The conversation rule holds. This doesn't seem to be the fundamental issue here because the parties had an agreement, had an offer and acceptance during a conversation. That could be some issue around consideration, but we have land for money. That looks like a bargain for exchange. So I don't see anything challenging about mutual assent and consideration here. Plus, that's not exactly what the prompt asked. Immediately after the call, Gundy sent $10,000 to Malhotra via Venmo, and Gundy captured it with a screenshot, which yours truly photoshopped. Just, again, a reminder, can't always believe our evidence. So we have this nice picture of the evidence at question here, where we have a screenshot, and the fact that 1 out of 4 pages of this entire exam consists of an image seems to suggest this image is relevant and important for our analysis. We're going to have to return to that image to see what features it has and whether it meets some kind of legal standard, but this image seems to be related to the concepts we're addressing. The next week, Malhotra departed for India, and Gundy applied with the New Hampshire Marijuana Control Commission. Who the heck is that, right? What has that to do with the question? Let's just, I'm kind of getting a reality check here, discuss the best legal claim Malhotra can make with regard to Gundy, and now we have Gundy and the NHMCC. That seems tangential, and it turns out that it is. This is the red herring in the argument. This was the rabbit that some of you may have chased, but the question does not ask anything about these parties, so I reached this point in the essay with skepticism. She applies for a grower's license. They condition the grower's license upon her building a DEA-approved marijuana vault. Gundy then enters into a written contract with Custom Vault Construction Services to build a vault for $250,000. It goes on for a little bit about the construction of the vault, typically made by pouring concrete into wooden frames, right? What could this have to do with Malhotra's refusal to sell the land? Not clear that these facts are relevant to the question presented by the prompt. And so I'm reading this in my mind kind of quickly here because there's a lot of detail about the strength of concrete. Quikrete has a strength rating of 4,000 psi instead of 7,000 psi, and the contract says this and that with these two parties, and CVC builds it with the wrong concrete, and then Malhotra wants it demolished, back and forth, back and forth. Code requirements, the drug enforcement agency's approval of this vault, a refusal to pay CVC because the wrong cement was used, a response by walking off the job. Again, a common phrase that we've seen, right, that should trigger our red herring issue of repudiation. But this is not the question asked. There is a repudiation here. Walking off an incomplete job is a total breach by repudiation. That's an issue in contract law, but it's not the issue being asked by the question presented. So that's not where we want to spend our time and effort, given that we only have 1 hour to answer the question presented. So Dr. Gundy refuses to pay, CVC walks off the job, expert testimony, something about the standard for the concrete walls and its useful life and what have you, while litigating with CVC. So now we have a snap back to the picture with Gundy. Gundy begins testing a special strain of contamination-resistant marijuana on the site. All right, what is she doing? She is improving the land, right? She is using horticulture to take a contaminated site and potentially grow something valuable. After a year of testing, Gundy successfully cultivated a strain of marijuana that thrives on this contaminated soil. Okay, she succeeded in doing something valuable, something productive with this land. All right, still not sure quite what to do with that, but that has to do with Gundy and Gundy's claim to the land, has to do with her relationship to the land. Gundy's marijuana strain passed approval, and she began selling it to local distributors. By the end of the second year, Gundy's business was earning profits of $3 million annually. She built a valuable business of $3 million off of otherwise contaminated land, right? And what does this have to do? Well, maybe now we're starting to remember, okay, there is an exception to the statute of frauds with regards to sales of land when a person improves land. We've seen cases regarding that. We have a restatement section 129 regarding that, partial performance and improvement of the land. That's seeming pretty likely, and it's in the bullseye zone of the topics that we thought to cover. Malhotra returns from a mission in India with a new perspective on marijuana use. She doesn't want to honor the contract because after her time in India, she doesn't believe in marijuana use. The doctor saw how violent gangs controlled marijuana distribution, and she now morally opposes its production. Okay, so she has a reason to either breach this agreement or to try to rescind it or to refuse it. Malhotra wants to shut down Gundy's business by reclaiming the site, and she hires you to analyze whether she has legal basis for doing so. Once again, after that episode with Concrete All and CVC and something, we're back to the story of Gundy and Malhotra and the land. And then we return at this point to our analysis of essay question number 1, discuss the best claim Malhotra can make to prove the contract to sell the site is invalid or unenforceable. So, having read all of that with that lens, looking for a defense, what are our defenses? Well, is there an incapacity defense here? There is no allegation that either party is under the age of majority. Right? There's no claim here that these are anything but adults. In fact, we could even assume that you wouldn't get a license to cultivate marijuana unless you were an adult. And I mean, people are not buying and selling land as children very often. There are no facts which suggest that there is any type of incapacity because of infancy. There's also no allegation of any type of mental illness. No one is using marijuana, so there's no alleged intoxication. So there's no intoxication defense here, right? Because there's no party which is using substances. There's no party which has any alleged mental defect or infirmity. In fact, there's no incapacity basis at all. There's certainly no allegation of like guardianship or anything like that. So we now turn to our checklist and I think strike out incapacity as a potential issue. The next issue on my list is statute of frauds. That seems very likely because we remember that statute of frauds has this helpful mnemonic, my legs, marriage, year, land, okay, that's a topic covered by the statute of frauds, executorship, goods for $500 or more, suretyship. Okay, we are in the statute of frauds. We need a signed writing. That seems like a pretty valid defense because we have this flimsy example of a signed writing presented in the form of a screenshot of Venmo, which, well, that may or may not be a memorandum as required by the statute of frauds. Let's just continue taking a look at our defenses to see if there's any other valid defenses. A mistake is a belief that's not in accord with the facts. Are there any mistaken beliefs here? Well, on the one hand, Gundy purchased the land knowing it was contaminated, and she doesn't want to rescind the contract. So there's no mistake by Gundy. Plus, she wants to enforce the contract. And how about Malhotra? Has Malhotra made any kind of mistake? Well, maybe with regard to the value of the land, but we know that as a matter of law, that's not the kind of mistake that counts. For one thing, that's a prediction as to the future. And for another, the land probably was worth $10,000 or maybe less in its spoiled state. So that was a fact that was probably true at the time of formation. So Malhorta doesn't have a valid mistake defense. Has there been any type of misrepresentation? And there doesn't seem to be. Nobody made any statements that were false. There were very few statements made at all. I would like to buy this land, even though it's contaminated. I will sell you this contaminated land. Okay, I agree. Nothing there seems to be beyond what is true. Do we have any other defenses? Well, we have duress and undue influence, but no one is holding a gun to anyone's head here. No one is making economic threats, and these parties are not in a special relationship. So there's no basis for any type of defense for duress or undue influence. And unconscionability, there's nothing wrong with the sale of land for a lawful business purpose. So we don't have any other defenses, and that brings us back to our initial inkling that this is about the statute of frauds, which it is. So let's take a look at that statute of frauds defense. And really there are two different ways I think we can approach these questions. One is preferred because this essay, really essays, split into two questions. The question was actually designed to, in many ways, help you with your organization because it had two discrete portions to it. One was the legal claim of unenforceability, and two was the equitable defense, if you will, or counter defense for enforceability despite the legal claim not being met. So we could have some kind of more complicated IRAC if the question simply asked, was there any reason why Malhorta could rescind the contract or not abide by the contract, and does Gundy have any defenses there too? We could have asked it that way, or I could have asked it that way, but instead there are actually two discrete questions. And so let's answer the question presented. The first question, discuss the best legal claim. So the issue is whether Anil Malhorta, and I'll identify her as the purported seller of site number X, has a legal basis to claim any purported agreement to sell that site to Karen Gundy is unenforceable or invalid. Again, I'm kind of quoting right from the prompt, remembering that an issue is a question, the answer to which will resolve the case. And here we're being asked a directed question, and we have most of the fodder for our issue statement. So that's the first half of our issue statement, our whether clause in our issue for IRAC, followed by our where clause where we identify specific facts, where the only plausible memorandum of the transaction is an electronic screenshot of the Venmo transaction. And again, the fact that this was printed in large and accords with defenses, accords with statute of frauds, accords with analysis of memorandum, that's why I've indicated that this, well, I don't know if it's a memorandum or not, whether or not this transaction screenshot, whether this is going to satisfy the statute of frauds, that's really what the legal question is asking, right? Is the statute of frauds satisfied? And then I go on to cite and recite, really, the restatement, which we can use in this restatement jurisdiction. If we were not in a restatement jurisdiction, we would easily find case law which says the exact same thing, because this is common law, this is common law of contracts. Under the common law statute of frauds, a contract for the sale of an interest in land is unenforceable unless there is a written memorandum or an equitable applicable exception that comes straight from restatement second, section 110 sub 1D, and I cite to that. But again, I'm just basically, it's a little bit of paraphrasing, but effectively citing the restatement regarding the requirement that we have a written memorandum for certain classes of contracts, including sales of land. A promise to transfer to any person an interest in land is within the statute of frauds. Again, citation, restatement second, section 125 sub 1. There's no question that this applies here. So I'm going to continue, and I'm going to smush, as I call it, several rules together into a rule block. Now, you don't have to do this. This is where I'm saying we could take a couple different approaches at this point. We could stop here and simply analyze whether this is a contract that falls within the statute of frauds. but that is a really simple analysis because contracts for an interest in land are within the statute of frauds, and this is undoubtedly a parcel of land. There is no question whatsoever the parties would say this contract regards a sale of land. So I'm going to use my time, hopefully more wisely, by smushing a couple rules together so I can move quickly through the obvious point about land and get to the more difficult point about memorandum, because that seems to be where the action is, and a quarter of the paper I was given shows me this memorandum that I probably have to analyze. So I continue with my rule block. A contract within the statute of frauds is enforceable if it is evidenced by a sufficient memorandum, which is any writing signed by or on behalf of the party to be charged, which A, reasonably identifies the subject matter of the contract, B, is sufficient to indicate a contract with respect thereto has been made between the parties or offered by the signer to the other party, and C, states with reasonable certainty the essential terms of the unperformed promises in the contract. Again, verbatim from the restatement. No creative thinking here. The only maybe creative move at this point was smushing the concept of satisfaction by memorandum with the concept of coverage of the statute of frauds. And again, I'm doing that because knowing that, I'm already, 15, 20 minutes into a 1-hour assessment, I've got to get to writing and getting points on the board for the issues that really matter. The signature to a memorandum may be any symbol made or adopted with an intention, actual or apparent, to authenticate the writing, as that of the signer, section 134. And then I have this kind of umbrella statement because I felt a little nervous about stopping there because there is, of course, the third part of equitable counter-defenses to the statute of frauds. So I just wrote for my comfort, this essay number 1 will deal with legal enforceability. Essay 2 will deal with equitable exceptions there too, because I will address these points later. And I want the grader to know I didn't miss this rule. I didn't miss this issue. I just organized it into part 2 because I identified that it was relevant to that part. In fact, I feel so anxious about this that I even suggest in my in my beginning of my analysis that generally we would take 2 analytical steps. But I'm trying to preserve time by addressing them in one fell swoop. I wrote, generally, statute of frauds issues are argued in 2 parts. First, whether the contract is covered by the statute of frauds, and second, whether there is a memorandum that satisfies the requirements. But here, only the latter issue would reasonably be debated. Both parties would agree that a purported contract regards the sale of site 197703001, which is unequivocally a parcel of land, right? There is no reasonable debate around the nature of this contract. It said in the beginning, I buy land, I sell land. It's identified as land. It's identified with a parcel number. There is no reasonable debate on both sides. That's not where the action is in this issue. Both parties would unequivocally agree this is a parcel of land, and so the statute of frauds would apply. The parties would likely disagree, however, about whether the screenshot of the Venmo transaction qualifies as a memorandum, right? And what am I doing? I'm trying to get to what I think is the essence of the argument so I can start getting points on the board for my analytical skill with regard to relevant issues under law. The statute of frauds requires there be a written memorandum signed by the party to be charged, which, and again, I don't want to just restate the law at this point. I've already said the law. I've already given my rule block. I want to do something with it. So I say the statute of frauds requires a signed memorandum by the party to be charged, which is Malhorta. That's important because I'm framing the analysis, right? Because it is the party who doesn't want the contract to be followed. That's who we need proof from. I mean, I literally did Photoshop this, right? I literally got Photoshop and made this up. And so could Karen Gundy, right? And that's why we look for a memorandum signed by the party to be charged, because it would really be Malhorta who needs to be this to be enforced against. She's the one who wants to avoid the contract. Malhorta and Gundy never entered into a signed formal agreement, right? I'm stating a non-fact, an obvious non-fact, but importantly, there isn't some standard sale of land agreement here. Maybe it was only $10,000, so they figured, what the heck, right? Maybe they're just not educated about requirements, but it's worth pointing out, usually land is sold with some kind of written agreement, and they don't have the standard sale of form here, so I cite that non-fact. The closest piece of evidence is the screenshot. And now I get into the arguments by both parties. Malhorta will argue this memorandum does not satisfy any of the three elements required by Section 131. What am I doing? Again, I'm making the parties' arguments. What does Malhorta want? Malhorta wants to avoid the contract. How will she do that? By showing that there is no memorandum, right? There's no debate that this is a contract for a sale of land, but does that sale of land have a requisite memorandum? That's not clear. And I think Malhorta's arguments are stronger, so I'm going to start with her arguments so I can get some strong arguments on the table, and then I will counter them with counter arguments. So first, the screenshot does not reasonably identify the subject matter because, right, I don't just state a naked conclusion or a bland conclusion, right? I mean, we know the rule is we need to reasonably identify the subject matter. Why does this not reasonably identify the subject matter? Because there is no indication of the land or why the money was sent on this screenshot. This screenshot doesn't say site number. It doesn't say for land. This memorandum doesn't include that information. And so I want to point out that element A is not met because particular information we'd expect is not on the purported memo. Second, the screenshot is not B, sufficient to indicate a contract was made because the screenshot does not indicate that there was agreement, but only that money was sent by one party to the other. That could be a unilateral, I was going to say a unilateral function, right? I mean, I can send Venmo to you without your consent, and my sending Venmo doesn't show that we agreed to any particular thing. It only shows what is the evidence that I sent money via Venmo. It might show that Gundy wanted this parcel of land for $10,000, but it doesn't show Malhorta accepted that transaction. And that's a problem, right? We don't have that aspect of the screenshot. The last date on this was 2020, November 3rd. We don't know what happened after this screenshot. Maybe what happened next was Malhorta sent the money back and said, I don't want this deal, right? We don't know what happened next. We only know what the evidence shows. And this evidence only shows Gundy sent money to Malhorta. The screenshot does not indicate C with reasonable certainty the essential unperformed promises, right? What would be the promises? One promise, to give money. The other promise, to transfer land. Where's the reference to the transfer of the land? We need the memorandum to evidence the unperformed promise. The performed promise, we know Karen sent the money. She has admitted that. She has agreed to that on the stand. She's trying to enforce the sale of this contract. What we don't have is anything showing that there are unperformed promises by Malhorta, meaning like to provide a deed for this land. Because the screenshot, once again, because, right? We want to tie our rules to facts and use them in our analysis because the screenshot shows money was sent but does not reference any unperformed obligations regarding the land. Additionally, this is only a screenshot and there is no input on here, which is obviously a signature. I think that's a fourth point for Malhorta, right? A signature is any indication the party intended to be charged. Where is that intention here? Right? What shows Malhorta intended to be bound by this? All right, let's give Gundy a chance. Everyone gets their counter argument. Gundy will attempt to argue the Venmo screenshot is a memorandum. That's what she needs to prove because it shows the parties and the amount transferred. Those are some material facts. Gundy will argue she had no reason to transfer a large sum of money to Malhorta but for the sale of some property. Gundy may argue the screenshot is not a memorandum made per such, but per Section 133, it identifies some transaction between the parties and thus could constitute a memorandum. Right? She's pulling out whatever, or we're for her pulling out whatever arguments we can. But now we have to resolve how the law should see this. As a matter of law, a court would likely find the Venmo screenshot is insufficient to charge Malhorta. Why? It shows only Gundy's account. There's nothing signed by the party to be charged. The image and name indicated receipt of money, but not evidence to transfer a parcel of property in exchange. There's no mention of the subject matter, and so there's no reasonable identification of the unperformed promises. Although the screenshot could be a memorandum not made as such, it would still have to meet the requisites of a memorandum, and it does not. Therefore, and again, we conclude by answering the question, what was the question presented? The question was, discuss the best legal claim Malhorta can make to prove the contract was unenforceable, and we end this, therefore, Gundy does not have a legal basis to assert enforcement of this agreement. So that's how I would approach number one, and that gives room to move quickly into essay number two, which is the equitable defense. And so I begin that with the issue statement, assuming that Gundy is not entitled to enforcement of the purported contract for the sale and purchase as a matter of law. The next question is whether she can make a claim in equity on grounds that she took action in reliance of the promise to transfer. Right? That's our exception. We know that the statute of frauds is a three-part analysis. One is a contract within the statute of frauds, right? That's the my legs thing. If this were a year or more of performance, maybe we'd have something interesting to say about that. But this is a sale of land. It's obviously within the statute of frauds. Two, is there a signed memorandum, a memorandum signed by the party to be charged? We've already answered that. No, there's not. Third, is there an equitable exception? And it turns out that there is a powerful equitable basis for enforcement of sales of land under Restatement Section 129, action in specific performance of sales of land, or rather action, what is the exact language? Action in reliance, yes, action in reliance resulting in specific performance of the sale of land, right? An action in reliance particularly pertaining to sales of land. So this is the most specific rule we can possibly cite, and that makes it the best rule for us to cite. Under common law, a contract for the transfer of interest in land may be specifically enforced, notwithstanding failure to comply with the statute of frauds, if it is established that the party seeking enforcement in reasonable reliance on the contract and on the continuing assent of the party against whom enforcement is sought has so changed his position that injustice can be avoided only by specific enforcement. Section 129, once again, verbatim from the restatement. Nothing particularly creative there. The creative part hopefully will come from advancing arguments by the parties. And here, Gundy has the better arguments. So let's start with Gundy's arguments. Here, Gundy will argue she qualifies for the part performance exception to the statute of frauds regarding the sale of land. In this case, during Malhorta's 2-year absence, Gundy acted in reasonable reliance by having a concrete vault built on the land and developing a strain of marijuana that thrived in this particularly contaminated soil. Now, there were some facts about this CVC, so maybe there's something to do with them. While the facility is not complete because her concrete vault is not made correctly, Gundy is taking actions to have a new concrete vault installed that will have a full useful life. Even if Gundy does not complete the vault, she has still made valuable improvements to the land that did not exist when it was in control of Malhorta. Additionally, the strain of marijuana thriving on the contaminated soil is the subject matter of a business generating $3 million in annual profits, showing improvement of the land. And Gundy had the concrete structure built and developed a strain of marijuana specifically for the land based on the reasonable reliance that she is the owner of this land. All right, that is my argument for Gundy. Moving then to Malhorta. On the other hand, Malhorta should argue that Gundy's reliance on her ownership of the land was unreasonable because she did not obtain a deed or other legal title. All right, that is a bit silly, isn't it? It is a bit silly to build a $3 million business literally on sinking sand or on a ground that you may or may not own properly. But that's why we have this action in reliance provision, right, to protect this exact situation. Gundy should not have, according to Malhorta, reasonably invested her time in building a marijuana vault on premises to which she does not have clear title. That may have been foolish of her. That may have been unreasonable. it may be unreasonable to invest $250,000 in property you may not legally own. But again, she acted like she thought she owned it, and that is the basis for enforcement under equity. Malhotra could also argue Gundy did not sufficiently perform action in reliance because she didn't complete the vault. Right? Again, I'm trying to use the facts that I have, including that this vault wasn't actually completed. The fact that Gundy would demolish the vault tends, according to Malhotra, to show that there have not been valuable improvements to the land. Right? If this vault is truly worthless, if it should be destroyed, that may be the best argument we have for Malhotra. Due to Gundy both building a new structure, therefore, a court should conclude that due to Gundy both building a new structure as well as developing a strain of marijuana specifically for this land, it is likely a court would find a part performance of a land transaction exception to the statute of frauds is necessary here to prevent injustice, right? A clear and unequivocal conclusion to the question asked. Again, what was the question that was asked? Assuming Malhotra can convince the court Gundy is not entitled to the site, anticipate the best argument for Gundy. The best argument is that she acted in reasonable reliance on the transfer of land, she improved the land, and as a result, she merits retention of it. So that's how I wrote these two essay answers. Now, if I were asked the question slightly differently, like if I were given a broader hypothetical or a broader prompt that did not encourage me to write essay 1 and essay 2, I would have needed a little additional framing. And we do that with what we call sub-IRACs. We could have written this in a broader way with some sub-IRACing. So the first issue, the overall issue, is the whole statute of frauds point, right? I mean, we could have, again, counterfactual, not what we are given in the prompt, but the overall issue is whether statute of frauds prevents enforcement, right? That's the overall issue. The rule is the three-part rule that we discussed about the statute of frauds, right? So does the FOF apply? Is there a memo? Is there an exception? And then we could have done a sub-IRAC, right? We could have, for our analysis, we might have analyzed these. That's a lot to bite off, right? That's a lot to do in one paragraph. So instead, our analysis could have been kind of sub-IRACs regarding each of those as separate issues, meaning an IRAC around the statute of frauds application, an IRAC regarding the memo, and an IRAC regarding the exception, which, by the way, constitutes the analysis of the rule we stated overall, leading us to an overall conclusion. That is not the best approach because here we were given two discrete questions, and the first question regarded these parts of the rule, the second one the exception. But if we were given a more open-ended hypothetical that pertained to defenses and responses generally, a IRAC with sub-IRACs followed by an overall conclusion would have been appropriate here. I hope this review helped you understand contract law, but more importantly, I hope it helped you understand how to approach an essay exam. By focusing on the question presented, you can answer the question. Instead of answering what you think might be relevant or what you imagine, you can get in the mind of the examiner and get the answer that is going to score you the points. After all, that's what you're here to do, right? Ace the exam. So I hope that this advice has helped you, and please feel free to leave comments in the discussion below around whether this strategy of reading the question first has been helpful to you and what suggestions you have to others to help them succeed in their essay attempts.